right, and we are now live. So, chapter 7. As of this chapter, most of you have completed 1/3 of the class already. Isn't that crazy? 1/3. That is a lot. In a little bit, it's going to be the exam. You guys are studying, right, at home? Yeah. By the way, you said you were going to watch yesterday.
Yeah, I was dying. As you can.
You were dying?
Yeah.
And you resurrected?
And I had cold and I felt upstairs. It's like great. I sneezed and I felt upstairs.
Are you serious?
Yeah, my shoulders all messed up. Yeah.
That's a powerful sneeze. I'm just saying.
I had socks on and I was like going down the stairs. I'm like, great.
Gotcha.
Yeah.
All right. So, quick heads up for everybody. Next time you buy stairs, don't sneeze. So,
Do not wear socks on.
all right, cool. No, but it's funny because you asked, you said I'm gonna watch and all that. I'm like, here, there's only one person, and then there's two people, which I think you're watching a little bit, right? And then it doesn't show me who it is, right? So I just see who's watching, like how many people are watching. That's all I know. And I'm like, Victor B said he was going to watch. But there's only one person watching, and I know it's not him. And then somebody was bouncing in and out. And I'm like, okay, all right. Maybe it was you.
Yeah, I did start watching on my phone.
Right before you fell.
Yeah.
Okay. So, next. That's funny. All right, ownership of real estate. Things are going to get a little complicated with this chapter. It is a very, very short chapter, but very, very long to deal with, okay? Because of confusion, because of the way the chapter is designed, okay? So, ownership of real estate. Title to a parcel of real estate may be held by one person, or there may be two or more co-owners of the property. Now, tenancy in severalty. In front of severalty, I want you to write one owner. I know severalty, the part several sounds like there's a bunch of owners. But severalty, when you put the T there, is like cut or severed from everybody else. You guys got it? So severalty, cut, severed from everybody else. Now, when we say one owner, we're talking about a person or an entity. So it could be one LLC, one corp, or one person. You guys got it? Okay. So it says right here, if title is held by one person or entity, that person is said to possess sole ownership or tenancy in severalty. Now, the term severalty means all interests severed from others, and when that person dies, something to remember about this one, when that person dies, title to the property will pass to his or her heirs, or devisees. Devisee is a person named in the will. Does anybody remember from yesterday, what is a demise? We talked about devise, but I made a reference to remember, Lucy, remember, not going back. Funny. I love when I say this. You guys remember, like, let me look at the notes. Demise is transfer of property by lease. So in the 5 rights yesterday, we talked about the right to possession, the right to use, the right of exclusion, the right of enjoyment, and the right of disposition or alienation. But within those rights was the right to build, and so on, devise, which is put in the will for somebody else, right? And it said lease. And I told you to put a circle on lease, an arrow, and write demise. Because I'm going to mention a few times. Devise is transfer property by will. Demise is transfer property by lease. Okay. All right. Next, we have tenancy in common. We call these ticks. Ticks. What is a tick? Does anybody know? What is it?
Talking about an insect or what?
Maybe. What is a tick?
Something that sticks to you and
It's annoying as hell, right?
Sucks your blood out.
And sucks your blood out. Guess what partnerships are in this case? Because technically, when you buy a house, you become partners. So two or more people not married to each other, right, become ticks. So it says right here, when two or more people own property, they do so as tenants in common. In a tenancy in common, each owner has an undivided interest in the whole property. Although a tenant in common may hold, say, 1/2 or 1/3 in the property, interest in the property, it is impossible to distinguish physically which specific half or third of the property is owned. Right? Look, listen, it's very simple. I put $10,000 into this property, you put $90,000 into this property, and it's a three family. How are we going to separate this? Does that make sense? It's physically impossible to distinguish which part of the property do we own. Okay? Now, something to remember, it's in green, tenants in common do not necessarily have equal shares. Now, this is in contrast with the next one we're going to address. So I need you to remember. That's why it's in green. So put arrows, stars, bubbles, whatever you want to put to call attention, that tenants in common do not necessarily hold equal shares. You know why this is important? Because as soon as you see in the state exam, 1/3 for John, 2/3 for Adam, I'm not saying these are the names, but just as an example, it's unequal shares, right? One has 1/3, the other one has 2/3, correct? If it's unequal shares, the correct answer is immediately, without questioning, without a shadow of a doubt, it's immediately tenant in common. If it's unequal shares, immediately tenant in common. So there's a few things I'm going to show you guys that you have to trigger. Like yesterday, we talked about 1866. Does anybody remember what that was? What is it? Race and color. Race and color, discrimination. You cannot discriminate based on race and color. That was 1866, Civil Rights Act. 1968, you should remember, there was race, color, and then they added religion and national origin. And they also added exemptions. But the things that need to trigger is 1866, race and color. Why? Because yesterday we said, for instance, that if a complaint is made based on race or color, you have to go straight to federal court. So you need to know the difference. If you're complaining of discrimination based on an 1866 law, race or color, then it goes straight to federal. You don't do complaints with HUD or anybody else, you go straight to federal court. It's a federal crime. Does that make sense? So these are things, triggers that you got to know. Here, don't waste your time. You see unequal shares. Unequal shares automatically ticks. If it's tenants in severalties, one owner, so there's no more than one share. Got it? If it's two or more people, it could be automatically tenants in common, but it can choose to be something else as well. And I'm going to address that in a second. But unequal shares automatically ticks. You guys got it? Okay, cannot stress enough that it's that important. They might have equal shares, but then you have to read a little bit more. But if it says unequal, 1/3, 2/3, tick, no matter what. Next. In a tenancy in common, each owner can sell, convey, mortgage, or transfer that interest without consent of the other co-owners. So I can sell my shares and I don't need your permission. Okay? Now, upon the death of a tenant in common, next page, that interest passes to his heirs, his or heirs, or devisees. So when I die, my shares go to my heirs. Got it? If a tenant in common wants to dissolve a co-ownership, but the other parties do not voluntarily agree to its termination, he or she may file a suit in court to partition the property. Question: what does partition mean? Yeah? Huh? No.
to go into an agreement and, I don't know, like sell the property and then take part, whatever part you use.
We're gonna get there, but the correct answer is separates. Put a partition that separates this unit from that unit. This wall is a partition that separates. Now, you need to remember partition for this reason. If it's possible, the land itself might be divided into separate parcels. This is a physical partition. We separate the land itself. You own this side, I own that side. Separate. Physical partition. But in the case of the three family that I told you, how are we going to separate this? Impossible, right? So, if the court determines that the land cannot actually be divided into parts, it orders the real estate sold and the proceeds divided, separated amongst the co-owners according to their fractional interests. And now this is called judicial partition. It's an order by the court to sell the property, receive the monies, and separate according to our interests. Does that make sense? So partition, it's a separation. Whether it's a physical, because it's easier to put a wall, as an example, or it's judicial. Court order, sell and separate the monies. But partition is a separation. Good?
Is that how condos came about? Do like this type of action? Just thinking.
Not sure. I would not be able to answer that. Condos are ownership. There's apartment buildings and then there's condos. So how they came to be, actually I've never checked into the origin of condos. It could be. Somebody bought a property and said, you know what? Let's separate this and sell individually. Maybe. They could be. That's a good thought. Never actually looked into it.
Yeah, because they do have those, like, that you can buy an apartment instead of a condo. So,
No, a condo is, we're going to talk about that in a second. All right. So, physical, judicial. You guys know the difference? Okay. Now, pay close attention to this. It's in green. Highlight, put stars, arrows, bubbles, whatever you got to put. In New Jersey, a conveyance to two or more persons, make sure you underline, not married to each other. Because there's a special type of ownership for people that are married. But right here, in New Jersey, a conveyance to two or more people, not married to each other, creates a tenancy in common. And this is automatically. That's why it says, unless otherwise stated in the deed. So if we choose to be something else, we need to specify in the deed. If we don't, automatically we are ticks. Bloodsucking can't get rid of each other, as you can pretty much tell from judicial and physical partitions. Right? Now here's something else. Remember I said I put 10,000 and Lucy put 90,000? Yes? So how would our shares be divided? So it's $100,000 to purchase. I put 10,000, she put 90. How would our shares be divided?
You get 10%, she gets 90.
If we don't specify in the deed, our shares will be...
Oh.
Exactly. Ain't I the smart one? I only put 10, let her put 90. We're still 50-50. Don't tell her about it. So that's the thing, because the deed becomes in effect a partnership. And if the deed does not specify the partnership agreement, so 50-50 or 60-40 or whatever, then automatically it is assumed 50-50. Crazy, right? Two or more people. If they don't have a partnership agreement, automatically they are ticks. And the deed itself determines the shares. You guys got it? Questions here? Isn't that crazy? I mean, Victor L has just been like, oh, you guys in expressions, they're amazing. He goes like, oh, he just opens his eyes like a deer in the headlight. Oh my God, really? It's so funny.
I don't talk much because of my face.
Yeah. No, but it's true. There's a lot of, this is just the beginning. Like, here's your first day, but for you guys, this is just the beginning. There's a lot of stuff I'm going to talk about, especially when we come to leases and mortgages and stuff. You guys are going to be baffled by the information that the public should know and doesn't. Okay? What if I put $1?
Still, it's not specified in the deed.
50-50. Now, here's the thing. In our arrangement, just to be fair, in our arrangement, I said I put 10% down, you put 90, so the 90,000, but I'll handle all the operations. So it's 50-50 because I'm doing the hard labor. Right? I don't put money, but I put work into it. So there's different types of agreements. Don't judge me for just putting 10 and she puts 90. Okay? There's a lot of times where that's what I do. I come in with the expertise and I borrow money for the investment. And instead of paying back interest, we become partners and we split profits. Creative ways. You guys got it? Anyway. Okay. Joint tenancy. So we have ticks. I told you guys, 2 or more people not married to each other automatically are ticks. But there's another option for people that are not married to each other. Another option, that option they have to choose. So 2 or more people can also choose to own property as joint tenants. That means we elected to be owners in this fashion. Okay? So joint tenancy or JT. The main feature of a JT is that it carries with it a right of survivorship. What does that mean? It means the death of one joint tenant of a property simply means that there's one less person in the group. And the remaining joint tenants receive the share owned by the deceased tenant. So to make this simple, okay? I'm really good at making circles, so you guys know. The best. To make this simple, A, B, and C owns property. Now, if there's a separation of shares, okay, if there's a separation of shares, and if you guys notice, I have the bigger share. In my examples, I always have the bigger share, I always survive, all that stuff, so just so you guys know. In this scenario, this is the equivalent to a tick. There's a separation of shares, unequal shares. Got it? In the JT, there's no separation. This is a JT, joint tenancy. Now, in the previous one, if C dies, the shares go to
A and B.
No, in the previous one, not JT.
Oh.
In the tick, if C dies, the shares go to heirs.
Yeah.
But here, in the JT, is the right of survivorship. So if C dies, it's just one less person in the group. Got it? When I kill A, I'm the survivor. I'm just a... You like that one. So like, yeah. Kill him. I'm the survivor of the group. And being a survivor of the group, JT is now over. I'm now a tenant in severalty. You guys remember that? One owner. Yes? Yes or no?
Yes.
Yeah, but in case only C dies and A and B is still alive, does
Then-
that share get split or just nothing happens?
Equal shares. That's the thing about this one. Equal undivided shares. I'm going to talk about that in a second.
Okay.
Equal undivided shares. Unequal shares, automatically JT. Equal shares, let's look a little bit further. If it talks about right of survivorship, JT. The last survivor, me, the last survivor, is a tenant in severalty. So if I happen to die, but I'll never die, just so you guys know, if I happen to die, the shares go to?
You heirs.
That's it. I'm the only one. The survivor is the only one that can pass it to the heirs. So, with that being said, if A or C had left this property in, or their shares of the property in the will, it would mean absolutely nothing. Because the way we organized our lives here was as a JT with a right of survivorship. Okay, so there's going to be that thought. There might be a question in the exam where it says John left everything in his will to his daughter Stephanie. Right? John and Adam own property as joint tenants. Upon John's death, who receives the property? And then it gives you 4 options. Is it going to be the daughter Stephanie? Is it going to be Adam? Is it going to be Stephanie and Adam, or none of the above? Correct answer is going to be Adam, because they own it as joint tenants. Even though John put in the will is moot because of this scenario. It's a JT, therefore right of survivorship. One less person in the group. You guys got it? If you intend to leave stuff for your heirs, then you want to have a tick, and you separate what's yours. Got it? So if C dies, it goes to the heirs. If A dies, it goes to the heirs. If B dies, it goes to the heirs. That's a tick. You guys got it? Question?
Once you're already on a joint, what's it called?
Joint tenancy.
Yeah, joint tenancy. Can you break that up and go to the one you just did?
So any change, that's a very good question. We're going to go over that. But any change to the current structure will break the JT. For instance, if C sells the shares to D, there's a separation. Now, it is assumed we have equal shares. So if that's the case, D just received 33% of shares. It's undivided, but because we're equal, there's 3 people, it is assumed 33%. You guys got it? So D gets 33%, but D is now, usually I address that a little bit further, D is now a tick. But A and B are still a JT. You guys got it? So my question now is, if D dies, what happens to the shares?
Goes to his heir.
Because it's a tick, heirs. If A dies, it goes to B. And JT is over because I'm the survivor of the group. So now both D's heirs and me, right, B, we are now officially ticks. You guys got it?
Yeah.
Yes?
If A and B dies,
If B dies, heirs.
okay. Even
Survivor
if
of the
D is
group,
still
heirs.
fine, even if D is still fine, A and B dies, it goes.
Sorry, say it again. Even
So
if what?
D is still fine. He's there. But if A and B dies. So
You're
that's
saying
what
that D
happens
did not die.
No, he's fine.
Yeah. Well, here's the thing. D is a tick.
Yeah.
So D doesn't have the right of survivorship.
So
He
has
broke the
nothing.
original agreement. Yes.
What if A and B die at the same time? They're partners, so they go under.
Never gonna happen. Never gonna happen. For several reasons. One of them, I'm gonna punch A until he dies first. That's the thing. Second, it doesn't matter because once you're declared dead, clinically, it's the first to arrive at the scene. So if they arrive at me first, they'll declare me dead first.
Oh.
Yeah, I teach insurance as well, so that's the worst part. If the other person is declared dead 2 seconds after, died second, and the second to die is the survivor of the group.
It
Therefore,
goes to the T's there.
That is crazy.
I'm telling you, if both of you are dying, punch the other person as hard as you can. Let them die first so you can survive and get the benefits.
JT is like
It's a joke, people at home.
JT is like the Hunger Games of real estate.
Sort of.
It's like the what?
The Hunger
Oh, Hunger Games. Yeah, pretty much the survivor. I usually go with a different quote. In the end, there can only be one, which is like the Highlander. Probably nobody knows what this is. Christopher Lambert, the immortals, you know?
Yeah.
Okay, so he's chopping off the immortals' heads because that's the only way they die, because in the end, there can only be one. Don't go out chopping people's heads. It's just a joke. I joke a lot. Don't take anything serious of what I say. Just saying. Watch on the news. Ella chopping heads. And based on Victor B's face, he goes like, yeah, I got this.
Question.
Mhm.
What if there's a chance that you cannot specify who dies first? Say it's a plane crash. You can't even.
It'll be the same thing. Again, plane crash, 100 people on the floor. I got to you first, time of death. Second, time of death. Second, a third, time of death.
So at that time, it's just like luck, pretty much.
Yeah, it's what I'm trying to tell you. The time of death is declared at the time they reach you. It's not like, hey, everybody here died at this time. No, it's when they go and assess you and make sure that you are dead. Once they assess you as dead, that's the time of death. Now, in an autopsy, they might be able to say, well, this person died actually 2 hours before. Does that make sense? But at that moment, it might change things, yeah.
So, okay.
But again, we're going like way off board and like criminal conspiracy, all that type of stuff. For state exam, they're not going to say, hey, what if this person died first? There might be a question that says they died, but it doesn't say this one died first, that one died second, that one died third, or clinically, this is what happened. Can they dispute it with an autopsy? Yeah, that's not part of the state exam. Got it? Great. My students get more and more creative by the time we get. It's unbelievable. All right. So before I go here, let's finish this part. This transfer occurs automatically, and I already told you guys that in contrast to tenants in common, joint tenants cannot devise. What does it mean to devise? Place in the will. Okay? Their interest in the property. As each successive tenant dies, the surviving joint tenants acquire the interests of the deceased joint tenant. And only the last survivor may dispose of the property by will, because that person now has an estate in severalty. And I already covered this, right? Now, how do we create joint tenancies? And this will explain a little bit more for Victor L, based on your question. To create a joint tenancy, 4 unities are required. Now, you have to have the unity of time, title, interest, and possession. So for now, just highlight and put stars around it. Time, title, interest, and possession. So, on the next page, it explains. These 4 unities are present when title is acquired by one deed, signed and delivered at one time, and conveying equal interests to all owners who hold undivided possession of the property as joint tenants. So these are the 4 unities. Title, one deed, right? Time, they're all signed at the same time and received it at the same time. Equal interests, right? And undivided possession. 4 unities. Without these, we don't have a JT. How do you terminate a JT is what I was explaining before. It's broken when one of the essential elements is, it's destroyed when one of the essential elements is broken. For instance, if we sell interest, then they become a tick, no longer JT. So everything we just went over, we just highlighted. All right. Next one we have is, on the right-hand side on top, tenancy by the entirety. Now, tenancy by the entirety is a special tenancy between husband and wife. The distinguishing characteristic of this tenancy are the owners must be husband and wife at the time they receive the property. For you to be considered joint tenants in this scenario, tenancy by the entirety for husband and wife is a joint tenancy, but for husband and wife, right? You must be married at the time, okay? So if the property, Victor, you had asked before, What if we already owned the property before, got married? Well, if it's before May 28, 1980, automatically it belongs to both regardless. If it's after May 28, 1980, then what matters is it your primary residence? If it is not, then it's ruled by this. Did you guys buy it together? If you bought it together, you must have been husband and wife at the time you received your property in order to qualify for this type of joint tenancy. Okay? What does that mean? You have the right of survivorship. So, when you're married and you own property together, and we kill the wife, the wife dies, right? What happens to the shares? See me just look at me like, what happens to the shares?
They go to you.
Thank you. They come to me. Right of survivorship is just one less person right there in the group when the wife dies. Got it? Yes? It's the right of survivorship. Husband and wife are like joint tenants. My question now is, see, I kill, but I bring her back. The question now is, what if we're divorced? We became ticks. Bloodsucking can't get rid of each other. Right? We split the property 50-50. Now, to make Simi happy, if the husband dies, what happens to the shares?
Goes to your heirs.
What is it?
You're ready to divorce, right? So it goes to your heirs.
Shares go to heirs. Not to the wife because she's the ex-wife.
Yeah.
Do you guys understand?
Yeah.
So, for it to go to the spouse, they must still be married. Once they divorce, they operate as ticks. They're no longer the joint tenancy. Does that make sense? Okay? So tenancy by the entirety is a joint tenancy specifically for husband and wife. Okay? There's the right of survivorship, just like a JT, but there's one more thing that you can't do, which is we cannot partition. What is a partition? Separate the assets like this is yours, this is mine, but we're still married. Or let me sue you for my half or your half, right? But we're still married. If you're married, the only type of lawsuit that we can get is a divorce. You guys got it? All right? Something to highlight. In New Jersey, a conveyance to a man and a woman who are legally married to each other creates a tenancy by the entirety unless the deed expresses or expressly states otherwise. So what we're saying here is simple. If it's one owner, automatically tenancy by tenancy in severalty. If it's two more people not married, automatically ticks. If it's two people married, automatically tenancy by the entirety. These are automatic. Can two people not married choose to be JT? Yes. Can two people married choose to be ticks? Yes. They have to choose. Otherwise, these are automatic things. You guys got it? Yeah? Questions? No? Yeah?
There's
I do. That's part of this section.
right. There's husband and wife, right? If husband or wife, they have kids prior to getting married from a different relationship and stuff like that.
Mm-hmm.
If one of them dies, can their kids from previous relationship come after it?
Okay, so that will be chapter 20.
Okay.
In chapter 20, we talk about law of descent and distribution, like who's entitled to what. If there's no will, the state will determine who's entitled to what. So there's specific rules for children that are not children of the surviving spouse. So there's specific rules for that, chapter 20. But what you're asking right now is the main reason, one of the main reasons why you should have a will. Because if you don't want to give anything to the children, you don't. The wife is still entitled to something. Again, chapter 20, we'll talk about that. But if you don't want to leave anything to the kids, or if you want to specifically give this to one kid, that to another kid, and so on, then the will determine that. Okay? You guys got it? If it's a tenancy by the entirety, automatically the spouse gets on those properties that they own together. Okay? But again, when we get to chapter 20, so towards the end, we'll briefly go over that. Okay? Now, partnerships. We talked about individual ownership. Now we're talking about partnership or business ownerships. So there's general partners and there's limited partners. As you guys highlight, in a general partnership, everybody assumes full liability. What does that mean? Well, if we make money, then we're all happy, aren't we? But if we get sued and only one of us can afford to pay the lawsuit, because it's a general partnership, we share liability. That means if I'm the only one that can afford, I have to pay for everybody and then collect from you guys whenever possible. That's general partnership. And if I don't have enough money, it goes beyond the business. It could go through my properties as well. I'll have to sell what I have in order to satisfy it. In the limited partnership, the second one, there's at least one general partner. One that takes the full liability, that tackles the whole business. One at least. And then there's limited partners. The limited partners do not participate in the operation of the business. They're limited to what they can do. But here's the thing, they're also limited on loss. They're limited or being held liable for business losses only, please underline, only to the extent of his or her investments. Only to the extent of his or her investments. You guys got it? So general partner, we share the profits, we share the losses, and one of us might be liable for everybody. Limited partnerships, I'm the one handling the whole business. You guys contributed money, for instance. What do you stand to lose? Money. A little bit of money. Not beyond that. So if you put $10,000, Lucy, right? If you put 10,000, but we get sued for $1 million, how much can they go after from you?
10,000.
10,000, right? And if you make your 10,000 back, guess what? You're safe. I'm liable for the whole thing then. You guys got it? General partners, limited partners. Now this limited partnership is a popular method of organizing investors in a real estate project. I have this house I'm trying to buy. You know, it's 10 units and it's going for 1.2 million. I just don't have all the money. Anybody here has $25,000? Let me get $25,000 from each. I'll handle everything and I'll give you guys 20% return on your money in 6 months. You see what I'm saying? This is a way to organize. I'm giving you an offer of return on your money if you invest in the project. This is not a real project. It's just an example, hypothetically, right?
It's also not guaranteed the return, right?
If I guarantee, then I make myself liable for it. So if I put down guaranteed, I'm liable for whatever I bring less than the 20%. Now, there's only two things in life that are guaranteed. One is that you're alive, and the other one is you're going to die. Right? So can I guarantee anything else? No, but some people do give out guarantees. And based on my experience, I can guarantee you that the average returns that we've got on properties, see the difference? The average returns we got on properties is roughly 20%. That I can guarantee that that's based on my experience, the average return. Totally different than guaranteeing I'm going to give you 20%. Now what you hear is one thing. You're hearing, oh, he's going to give me 20%. And what I said was, you might get 20% based on past experiences. You guys got it? What if you get 1%? Can you sue me? No, because I told you the average returns. Okay? So be careful if anybody gets involved in this type of transaction. He promises you the world and you're going to get this return and all that stuff.
So basically, so that's an unlimited partnership. And if there is a sue, the 1 million example, so you be liable for everything.
Well, you would lose your
I would lose like
$25,000 investment.
$25,000, but you're gonna be liable
Yeah.
for the rest.
You're protected for the rest. You're limited.
Okay.
Yeah. You have limited liability.
Yeah.
Okay. You guys good so far? Told you short chapter, but a lot, right? Corporations. Can you own a property under a business name? Absolutely. In fact, you should. Because a corporation is like a legal shield, a separation of that liability I told you before, right? That goes even beyond the business. It goes like to your personal assets and everything. A corporation separates you, the person, from you, the business. So if the property is owned by a corporation and somebody slips and falls, they're suing the corporation and not you. And they cannot come after you if there's not enough in the corporation. The liability is limited to the corporation. Does that make sense? All right. So corporation is an artificial person or legal entity created under the laws of the state from which it receives its charter. Now, because the corporation is a legal entity, real estate ownership by a corporation is in severalty or tenants in common. If there's one corporation owning it, severalty. If there's two corporations owning it, corporation A and B, they're ticks. Makes sense, right? Now, because of its possible perpetual existence, a corporation cannot hold real estate as joint tenants. What does perpetual mean? Lasting
Forever.
forever. Corporation could last forever. You got it? We have an expiration date. Well, not Ella. She's going to be here for more than 100 years. But corporations don't have expiration dates. We do. One day we will expire. Can we terminate a corporation? Dissolve a corporation? Sure. But naturally, they might last forever. Got it? So, as a legal entity, a corporation exists until formally dissolved. The death of one of the officers or directors does not affect the title to the property that is owned by the corporation. A corporation is managed and operated by its board of directors. These are people appointed to run the business for us. Okay, so let's say we all buy property. We put it under a corporation. And some of you, instead of being limited partners, you are the stockholders. You're like, I don't want to deal with this thing. So, hey, Victors, both of you, you handle it. So we appoint you as the board of directors. And you handle everything. You're like the general partners, but in the corporation. Now, are you liable? No. Difference between partnerships and corporations is that separation. You guys understand? If we get sued, who's getting sued? Is it the board of directors? Corporation. You got it? Can they come after the stockholders? Unless we committed fraud? No. You guys got it? Now, as it says, each shareholder's liability for the corporation losses is usually limited to the amount of his or her investment, just like limited partners, right? Now, right before it says, because stock is personal property, shareholders do not have direct ownership interest in real estate. So who owns the building?
The corporation.
The corporation. What do you guys own? Stock. Do we own the real estate?
No.
No. We own stock that owns the corporation that owns the real estate. Got it? So these are like layers. Let's put it like that. On the right-hand side on top, we have LLCs, limited liability companies. These are my favorite because they're easier to manage, just like partnership, right? They have the legal shield or the protection just like a corporation, and tax advantages just like a partnership. So it's a pass-through entity. So you're not getting double taxed like in the court. Okay? You guys got it so far? LLC members have tax advantages offered by partnerships, at the same time limited liability offered by corporate form of ownership. What I usually say is that if you're 1, 2, 3, maybe 10 owners of property, right? Put it under an LLC. Once you start gathering more investors, it becomes a little bit more complicated to manage, get it to a corporation. But either way, whatever your situation is, you should consult with a CPA. Everybody's different. Maybe you don't belong in a corporation. Maybe you don't belong in an LLC. Partnership might definitely not be the best for you. I'm sorry?
I have no.
LLCs are easier to establish than a corporation, right?
To establish, both the same. To maintain, totally different.
So basically, if I have an LLC on my name and I have multiple properties, I can just.
If you put all your properties in one LLC, then you can lose all your properties in one blow.
Okay.
I'm trying to tell you to separate yourself from the business. So
Yeah.
obviously separate each business.
Which LLCs?
You want to put a chain of restaurants in the same exact name? They could be doing business as, but you don't want them in the same exact name. Because if something goes wrong in one restaurant, you lose all your restaurants. Somebody slips and falls on one of your properties, liability extends to the next one and the next one and the next one. Not the properties themselves, but the LLC. So it has to be satisfied somehow. You got it? So some CPAs will go against what I'm saying. Some attorneys will go against what I'm saying. People that understand investments traditionally will tell you, yeah, keep everything separate. And again, it depends on the purpose. If you're just buying and selling, short term, maybe not much of an issue. Me, I panic with everything. I'm buying and selling, it's quick, yes, but if somebody slips and falls during construction, I'm still getting hit. You guys understand? So I still prefer to, it's only like $100 or $150 to open an LLC, and to close it, nothing. You just pay whatever is due in taxes and stuff.
Yeah.
So let's say you pay a service to get it done. Pay like $350 or $500 a pop. You're buying an investment of $200,000-$300,000. What's $500 to create an LLC? Does that make sense?
So it's easier to open an LLC for each.
Mhm.
Okay.
But don't go by what I'm saying. Make sure you have a CPA, all right? And that CPA helps you, and an attorney. They help you with those things. Okay? Again, some people say I'm crazy. Some people support my ideas. There's always different kinds of people and different kinds of mentors and investors out there. All right, other forms of ownership. We have syndicates. A syndicate is a joining together of two or more people to carry out a particular business project. Yes.
A syndicate could be something like a union
Mhm.
thing, or yeah.
It could.
Okay.
But we're going to go in detail in chapter 17. Okay? Now, a syndicate could be a joining of, it says two or more people. It could also be, a syndicated venture could be between different LLCs, different partnerships. Could be like a mix and blend, right? And it says here, joint venture is an organization of people or firms designed to carry out a single project. So joint ventures last for a limited period of time and do not establish a continuing relationship. So I personally, at this point in my life, prefer joint ventures, which is, guys, I have a property, $300,000. It's worth roughly $500,000 after fixed, $50,000 to fix. So $350 is what we're in for. But we can make $150 profit, more or less. You guys in or you out? If you're in, this is how we're going to play it. We're going to open an LLC. We're all members of the LLC. We buy the property. We sell the property. We dissolve the LLC. It was nice to meet you. Simple. Do you want to repeat it? Did you like it? Let's do it again. There's another property. $400,000. $50,000 to fix, right? So we go through the same thing. Do you guys want it? Great. Open an LLC, fix the property, sell the property, close the LLC. Was it good? Great. Nice to meet you. Do it again if you want. Joint venture, short period of time. It's not an ongoing relationship. You guys got it? It's ongoing as far as we knowing each other, but the LLC itself is short period of time. You got it? Yes? We also have REITs here. We're going to talk about it in chapter 17 in detail, so for now just skip. And we get to the growth of condos and co-ops. Growth of condos and co-ops. Now, second sentence there says, together with townhouses, plenty of developments, condos, and co-ops offer the emotional, financial, and tax advantages of home ownership combined with various advantages of apartment living. If you skip a paragraph, it says, contributing to the growth of condos and co-ops are changes in population patterns, with increasing numbers of single homeowners, one-parent families, and senior citizens. To such groups, community living offers security, sociability, ease of maintenance, and sometimes the opportunity to share expensive recreational facilities like swimming pools and exercise rooms that nobody uses. But they're there. Isn't it true?
Yes.
I know it's true. It's like just like a regular gym or like a regular pool. It's empty throughout most of the year. Once in a while, somebody goes there and yells cannonball and stuff. Just for the fun of it, quick video on YouTube, good. All right. So, what we're going to do right now, and this is going to be real quick, what we're going to do right now is compare condos and co-ops. So once we're done with condo ownership, we're going to skip establishing a condo and condo conversion. We're going to go straight to co-op. Once we're done with co-op, we'll come back to establishing a condo conversion, and we finalize the chapter with time scans. Okay? So condo ownership. I want you to create a table. So this is what we're going to do. I don't have much space here. But what I want you to do is you're going to do this. Separate it. And you're going to write on one condo, the other one co-op. And I'll tell you exactly what to write as we go. All right? Okay. So create these two separates. Okay. So here's what I want you to write. On the column for condo, you're going to write deed. Because buyers of a condo receive a deed conveying fee simple ownership to two things. Their living unit, from the paint on the interior walls inward, so from paint in, paint out, it's no longer yours, right? And a proportionate undivided interest in common elements. So the swimming pool, the elevators, and all that stuff, it's not like you own a button on the elevator. You own the whole thing, undivided interest. Does that make sense? Mm-hmm. So what do you get with a condo? Deed, title to something, to this box. Okay, title. Now, chief among common elements are the land and the exteriors of buildings. Common property can also include hallways, basements, elevators, stairwells, driveways, private roads, sidewalks, lawns, landscaping, and recreational facilities. Now, in many respects, a condominium owner may be regarded with the same light as the owner of a single detached house. Title may be in severalty by the entirety as joint tenants or as tenants in common. The unit receives, please write individual. You're going to write there, individual. And right below individual, you're going to write tax bill. Tax bill. Right underneath tax bill, you're going to write mortgage. Because the unit receives an individual tax bill and maybe mortgage as a house would be. Okay? The other thing you're going to write underneath mortgage is insurance. Because the owners place a separate insurance policy on their living space. You got it? So condo, you get a deed, and you get your own tax, mortgage, and insurance bill. Individual, okay? Now, income tax advantages are identical to those for single-family homes, and the owners are free to sell the property, lease it, give it away, or leave it to the heirs. What I want you to do on that table, go to the column for condos, and you're going to write lease. Because you can rent your space, it's yours, all right? And this is going to be in contrast with the next one, with co-ops. That's why I need you to break it down like this, okay? So you can lease it. Now, each unit is a financial entity. And if an adjoining unit is foreclosed, no obligation is incurred by the other owners. So under condos, I want you to write independent financial entity. Independent financial entity. So what did we just say? Well, we said that if the person next door loses their property because they didn't pay, does it affect our ownership?
Yeah.
No. It affects the value of the house, but not the title to the house. You guys got it? So condos, you get a deed, you get your individual tax bill, mortgage, and insurance. You can rent it to somebody else, and you are your own financial entity, so you're not affected by everybody else. Good so far? There's something else. Owners are, however, bound by the bylaws of a homeowner association to which all belong. See, because we're several owners in the building or the community, we're all partners. Okay? Now there's trustees for the owners, right? Somebody appointed like board of directors. They're appointed to handle all the affairs of the community, including enforcing the bylaws. So I want you to write on condos, you're going to write HOA, Homeowners Association. Okay? Right below HOA, you're going to write bylaws. And right below that, you're going to write monthly fees. So, as long as rules are not unreasonable, New Jersey permits associations to enforce their rules by fining residents who fail to comply. Monthly fees are levied for maintenance, insurance, and management of common elements. If unpaid, please highlight, underline, put stars. If unpaid, these common charges become a lien against the individual unit and may even be enforced by foreclosure.
Oh.
Mm-hmm. So go ahead, don't pay your dues. The bylaws also set up covenants, conditions, and restrictions, CC&Rs. That's what you're going to write below that, CC and R. Covenants, conditions, and restrictions. Which, for example, may prohibit the display of a for sale sign or painting the front door bright red. It's a condo association. You own from the paint in. From the paint out, HOA owns it. So the homeowner association can say all doors must be the same color. You cannot put a for sale sign because that destroys the view of the neighborhood. Why is somebody selling? Does that make sense? HOA, they could even say no cars parked in front of the house. As long as the rules are not unreasonable, it says. New Jersey allows them to create these orders, CC&Rs, and fees for maintenance. Any questions? No? Let's go real quick to co-ops and then we'll come back. Co-op ownership. Co-op ownership, which is common in New York City, is also found in certain areas of New Jersey. Under the usual co-op arrangement, title to the land and building is held by a corporation. Each purchaser in an apartment building receives stock in the corporation and a proprietary lease, which gives the purchaser the right to occupy his or her apartments. So what I want you to write under co-op is stock and proprietary lease. So with the condo, you receive a deed, title. Here, you receive stock and a lease to occupy your unit. Good so far? Now, the cooperative's building real estate taxes are assessed against the corporation as the owner, and there's usually one underlying mortgage for the entire parcel of real estate. Taxes, mortgage principal and interest, and operating and maintenance expenses of the property are shared by the tenant shareholders in the form of monthly maintenance charges. So what are we saying here? I want you to go to the column that says co-op. Ready? And you're going to write shared instead of individual with the condos. Here you're going to write shared, tax, mortgage, insurance, and maintenance. You guys got it so far? Good? Okay, great.
Can you say that one more time?
Shared tax, mortgage, insurance, and maintenance. So, it says right here, thus, even though co-op owners do not actually own real estate, they own stock, which is personal property. Because who owns the real estate? The corporation. That's it. You own stock. Now, it says, for all practical purposes, they control the property through their stock ownership and their voice in the management of the corporation. Co-op bylaws generally provide that each prospective owner must be approved by the board of directors. So what you're going to write is board of directors. Okay? Below board of directors, you're going to write bylaws. You're also going to write approval. I'll explain approval. I'll explain that in a second. And you're going to write landlord. In landlord, you're going to put quotation marks. No. Where it says landlord, you're going to put under quotation marks. Because the board of directors acts as the landlord. The corporation is the landlord. We are tenant shareholders. So the individuals are tenant shareholders. If you guys want to write that down, we're tenant shareholders. So if we are tenants, we have to be approved by the board of directors to live there, just like a regular landlord. Okay?
Question.
Yes.
Since the living arrangements is contingent on being approved, does that also have to do with following certain laws as far as
The bylaws.
No, I mean like the regular laws as far as like discrimination goes, that doesn't apply.
Of course it does. Everything applies. Discrimination applies to every single transaction, especially rentals. And this is a rental. Okay? Discrimination in New Jersey. There's only a few exceptions we went over yesterday. And those exceptions are for rentals. We cannot discriminate at all. The approval that I mentioned was financial approval. Because one disadvantage of a co-op is that the possibility that if enough owner-occupants become financially unable to make prompt payment of their monthly assessments, the corporation might be forced to allow mortgage and tax payments to go unpaid. So, Ella, the approval is because through such defaults, the entire property could be ordered sold by court order in a foreclosure suit. So that means that even those that were paying on time lose the property. So you're gonna write shared liability or shared financial entity, because in the previous one we put individual financial entity. Here you can put shared financial entity. Crazy, right? Because remember, you're tenants. If I own a 100-unit apartment building and I rent to 100 tenants and they stop paying, what do I lose? Everything. You guys got it? You are tenants. That happen. I call you guys, if you're a tenant shareholder, I call you guys glorified tenants, because you're a tenant with stock in the corporation that owns the building. That's what it is. You're not owners of real estate, you're owners of stock. Yes?
When it comes down to selling, is it easier or is it a little complicated to sell your stock?
Very difficult.
Is it?
Unless it's an upcoming area and like, look, it's easy to buy, very just like condos, easy to buy, very difficult to sell. Because not a lot of people understand the concept of a co-op, of you being a tenant and owning stock. What you're paying for is the stock, not the unit. What you're paying for is the possibility of the building going up in value and you owning a percentage of that when it's sold at a future date.
Okay, so you own the stock of the building, right?
Yeah.
So, not the actual corporation. That's like.
No, you own the stock in the corporation that owns the building.
Okay.
So you are the owner of the corporation.
Okay.
One.
One of multiple owners of the corporation.
Okay.
The corporation manages the property and expects the building value to go up.
So that's sort of like an investment.
It is an investment.
Okay.
It's just not a full-blown investment into a property by yourself. It's a half investment where you get to be a tenant and stockholder.
Yeah, you can win, you can lose.
What's a good benefit about doing that? Is it cheaper?
Cheaper. Because there's one tax bill, one insurance, one mortgage for everything. All right, if I were to compare, in my professional opinion, if I were to compare, single family home, 1,000 square feet. Nothing else to be stated so far. In the same town. Condo, 1,000 square feet in the same town. And co-op in the 1,000 square feet in the same town. Most expensive, single family. Average, condo, least expensive, co-op. The problem is co-ops do not exist everywhere, just like condos don't exist everywhere. So usually when agents talk to you about stay away from this or stay away from that, they're comparing Jersey to New York, for instance, because New York is where it's popular, the co-ops, right? So how can you compare something here in Jersey to something in New York? As a matter of fact, when we get to Chapter 16 appraisals, how can you compare something in Harrison to something in Newark? Does that make sense? So you either compare apples to apples and oranges to oranges, or don't compare at all. And that's where most people fail. What you need to compare is 1,000 square feet in the same town. 3 bedroom, 2 bath. Does it have a garage? Great. Does it have a pool? Great. We'll compare to that. And then here comes the other side of it. If you own a single family house with a pool and all that stuff, you have to maintain it. Forget taxes. You're maintaining it. Very expensive.
And taxes as well.
As
They
well.
go up.
But in a condo, the taxes also are up. But no maintenance. You're paying monthly $200-300 for somebody else to do what you would do for $300 or $400 because it's shared for the whole thing. Does that make sense? So you're saving. You go to co-op, same scenario, but with the benefit of shared taxes, shared mortgage, shared everything. You guys got it?
It's the same as a condo, but cheaper. Let's put it that way.
Pretty much, and you don't get the deed.
Yeah.
Yes. Sorry.
When you do a co-op, do you get information about the mortgage and all that kind of stuff? Like the full, numbers about how much are they actually paying? Is it an adjustment
Because you're-
rate?
Because you're a shareholder, you're entitled to see all that stuff. Yeah.
Okay.
All right. Now, many co-ops do not permit rentals.
Oh,
Remember, in the left column in condos, I told you could write lease because you're allowed to lease or rent your unit. Co-ops, you may not be able to rent your unit because you're a tenant. So if you rent your unit, you're subleasing. That's why I enforce the fact that you're tenants. So you understand, subleasing is illegal unless you get approval by the
Board of
landlord.
Directors.
Okay, who's the landlord? Board of Directors. You guys got it? So A recent New Jersey law provides that owners of co-ops in buildings with 10 or more units may rent their units if, please highlight, underline, put stars, if they've been trying to sell for 4 or more months at a price no greater than their investments.
Oh, then.
So you bought it for $100,000. Now you can't afford the monthly assessments. You have to try to sell it first.
And you can't make a profit.
If you want to rent your unit, no. So you have to try to sell first.
Then that's not a, I don't see that as a
Benefit?
exactly or sort of
Not a benefit at all.
investment or any of that.
Nope. So at this point, you tried to sell. Hey, landlord, I tried to sell. Board of directors, I tried to sell. Can I please now rent my unit so I don't lose my investment? Do you guys understand?
Yeah.
In the end, cooperative living tends to develop somewhat different from condo occupancy. Long-term stability of tenants is common. Now, the corporation's right to accept or reject any new owner is aimed at safeguarding present owners. So, as I was explaining before, who would share financial responsibility for a defaulting neighbor. But it's often also to maintain a particular level of occupancy. If I select my tenants, again, based on financial, if I select my tenants, most of them will live here and stay here for a long time, right? There's no reason for them to leave. They're in the same level, let's say. So people that make $250,000 live in this condo. People that make $500,000 live in that one, in co-op, I'm sorry. Does that make sense? I try to approve them based on those minimum standards that we feel necessary for this type of co-op. You guys got it? Questions? All right, so let's go up to establishing a condo. So previous page. Establishing a condo. All you need to know right here is that in New Jersey, the creation of condominiums is regulated by the state's Horizontal Properties Act and the Condominium Act. Okay, this is common sense, right? Establishing a condominium, which act? Well, Condominium Act. Easy. And the Horizontal Properties Act.
Do they also establish prices and all that kind of stuff or no?
Prices is on here. Okay. Condo conversion. Where it says condo conversion, the landlord who desires to convert a rental apartment building into a condominium must obtain approval by the state of New Jersey at least 3 years and 2 months before the new conversion may start. Don't ask me about the 2 months, but at least 3 years ahead of time. I'm going to change this from apartment building to condos, to individual units, right? At least 3 years and 2 months before it may start. Now, certain tenants with disabilities and those age 62 or older may not be evicted during a condo conversion. Tenants so protected must have occupied the property for at least 2 years and have incomes no higher than their than 3 times their county's per capita income, or in any case, no higher than $50,000. If they meet these qualifications, they are allowed to continue as tenants for up to 40 years. So I can sell, I have 100 units, I sold 98, and I'm stuck with 2 tenants that meet these qualifications. They're allowed to be tenants there for up to 40 years, but paying tenants, not for free. Okay? Questions? No? Right-hand side, townhouses. Right here, all you need to know is that a townhouse describes an architectural structure in which buildings share a party wall. So townhouses are houses in a row, pretty much. You guys got it? And lastly, time scamming. So, the buyer of a timeshare receives a fraction of a year's ownership or use of a property, which might be a hotel, townhouse, single-family detached home, campground, or even a motel. In some cases, please highlight, only the right to use is purchased. In others, the owner has a true fee simple interest in the real estate. That means you own it. Although the concept is most popular in resort areas such as the Caribbean, Colorado, Vermont, and Florida, it has been used in Long Island, the Poconos, and other nearby resort areas. An owner, please highlight, can exchange, sell, or rent the time slot, subject only to any restrictions in the prospectus of the organization administering the property. It is not unusual for an interval to be for a specified week for each year. So a timeshare, traditionally, vacation spots, you get 1 week out of the whole year. You guys got it? Then you're entitled to that for like 5 years, or if you purchased it, true fee simple, you own it forever. Got it? Questions?
Okay, I didn't understand. So basically, you bought it?
You ever been to Orlando, to Disney?
No.
Okay.
Yeah, Poconos and stuff like that, yeah. So
To resorts?
Yeah.
And did they pop up and say, hey, come watch this presentation? Did anybody?
Yeah.
Okay. When you go watch that presentation, they're trying to sell you a week in the whole year. So that means you reserve that week forever. It's yours. So you pay up front for the benefit of several weeks. You got it? So you know you have a vacation spot whenever you want.
So like $50,000 and you can get like 5 years that week every year.
You give me $50,000, I'll get you 2 or 3 of those.
Well, you know, more or less.
But yes, that's
Okay.
mainly it. If you pay a little bit more, then it's yours.
Okay. And then you can like rent it for vacations and stuff like that.
You can exchange, you can
Okay.
sell, you can do whatever you want.
Got it.
You can use it. Most people don't use it, they don't exchange, they don't sell, they don't do anything, they just waste the money. And that's why I call it time scam.
Can you use that as an investment?
Yeah. Subject only to any restrictions in the prospectus of the organization administering the property, which they don't give to you until you sign the contract. So,
So you never know.
yeah. But I do advise you guys, go to as many time scams as you can because they offer you free food, beverages, tickets, bunch of stuff.
Phone, yeah.
I go to as many as I can. Just saying. You just got to be strong enough to say no at the end. And do not bring your spouses.
Yeah, but
Because
they
they'll-
get very offended when you say no. They can get nasty.
They can. But the problem is, so last time I went there, I was accompanied, and, you know, I'm just looking for the free tickets and the food and shows and all that stuff. So I'm sitting there and I'm listening to the spiel, 45 minutes, I gotta go, because I have an event to go to. This was in Vegas. And they're going at it. And my spouse goes, The moment she did, to something that the guy was saying, he's looking dead at me. As soon as she went, his attention was now to the most vulnerable person in the room, the person that acknowledged what he was selling. So now the whole conversation was boom, boom. Are you going to let her not have this benefit? Boom, boom. You see, she wants it. Boom, boom. And I'm like, under the table, I'm like, stop. You know, say no. Very important. Say no. But anyway, we were able to get out of there because I was demanding the contract. I will not sign anything without reading. Oh, we have 30 days to cancel the contract. And nope, I'm not signing without reading. Because they know once you sign, most people forget about the review and they already paid for it. So, you see what I'm saying?
But is it legal not to give you the contract before?
You have to have at least 7 days to cancel.
But like, is it?
No, it's not illegal. That's why they give you an opportunity to cancel. So in Jersey, it's 3 business days, but if it's a timeshare, at least 7 business days. Crazy.
It's like when you open a subscription online, they give you a week for free, but you still got to plug in your credit card.
Yep.
After that week, you completely forget about it. Boom,
They
they charge
charge.
you for the time off.
That's it.
Happens a lot.
It does.
Mm-hmm. All right, guys. Do you guys have any questions? No? Good class?
Yeah.
Easy to understand? A few difficult terms, but I hope I made it easy.
Not yet.
All right, so we're done for today.